Well, eNCA reporter Karyn Maughan is at the South Gauteng High Court for us this lunchtime. Karyn, grounds for this appeal regarded as weak by some. Just outline the president's argument.
Well, the president's advocate, Kemp, facing a barrage of questions by the judge who imposed the original order in this case. Of course, Judge Rami Matopo has to be the person that sees that there's grounds for an appeal. Kemp has to convince the court that another court may come to a different decision if this appeal is allowed to progress. He, of course, wants it to go to the Supreme Court of Appeal. Judge Matopo pointing out to him that essentially what he's asking is that this case go back to the court that first granted the order. Of course, the SCA was the court that initially said that a so-called reduced record of the Zuma with charges withdrawal decision must be provided to the DA so that it could prepare an argument to argue that all the charges being dropped against Jacob Zuma was an irrational decision. Now, Kemp pursuing this argument, as he says, saying that those tapes and transcripts formed part of the representations to the NPA that Jacob Zuma made as part of his bid to avoid prosecution on nearly 800 charges of corruption, fraud and other financial crimes. He's saying that as such, under the NPA Act, those submissions cannot be disclosed. However, he is being slightly undermined by the DA's argument that, in fact, the head of the NPA went on affidavit to state that those submissions were never part of the record or of representations furnished by Zuma, but were in fact supplied by the National Intelligence Agency and therefore do not and should not enjoy the same level of confidentiality as Zuma's representations.
There's an awful lot at stake here for the president, isn't there?
Well, essentially, Andrew, the point to be made here is that this style of litigation is not unusual for Jacob Zuma. During his corruption prosecution, he made many similar trips to various courts across the country to argue against the warrants that were used to conduct search and seizures on his premises, the mutual legal assistance requests that were put forward to Mauritius in order to obtain so-called evidence against him. His lawyers have consistently maintained that they would adopt a so-called Stalingrad approach to litigation involving so-called corruption charges against him, and they are doing the exact same thing. Inevitably, what the DA is arguing is that this whole process of attempting to stop these tapes and the transcripts from being given from Jacob Zuma and the NPA to the DA is merely to thwart their inevitable court attempt to force him to face those charges again. And as such, there will be a lot of delays and kind of similar applications going forward. Of course, he will argue that this is his constitutional right and that indeed part of those representations and part of those tapes contain information which is confidential to him and which he doesn't want to disclose. His big problem, however, Andrew, is this court saying that Jacob Zuma cannot simply make that assertion. He has to prove it, and he has to show this court why those tapes and transcripts, having previously been disclosed in part by the NPA, are so problematic for him.
Just when are we expecting a ruling?
Well, as we speak now, the arguments are still underway. It is quite possible that the judge may decide to provide a ruling even today. However, it is more likely that he will reserve judgment in this matter and give a ruling in a few days' time, possibly next week.
Karyn Maughan at the South Gauteng High Court for us in Johannesburg. News that moves. eNCA.com.